Hello and good morning, everybody. My name is Roisin Kelly from the Equality Commission for Northern Ireland. We are delighted to welcome you to today's annual employer update. We're really pleased to see so many employers from across Northern Ireland logging on to join us for today's event. I would also like to extend a very warm welcome to our colleague Mark McAllister from the Labour Relations Agency. Mark will be co-delivering today's event, and we are delighted to be working in partnership with Mark and the Labour Relations Agency on our event today. I want to briefly mention at the outset that live subtitles are being captured in the background of today's event by our colleague Orla, our text writer. If any of you would like to access this service, you can do so just by clicking on the link that our colleagues have posted in the live Q&A for today's event. Okay, so here is our programme for this morning, including timings. The event is being recorded, so we will be making a recording of the live event available to attendees after today. We are welcoming questions from attendees during today's live event, so we would encourage you, if you have any questions for either of our speakers, please do type your question in. Again, using the question function that you'll see on your screen. We will publish some of your questions, time permitting. So if you do wish to be anonymised, feel free to do so because your name and company name will appear on the live Q&A. We will only have time to publish and answer a selection of questions, but we will be directing employers to sources of further information and support from both organisations during today's session. Okay, so I would like to begin by welcoming our first speaker, our Chief Executive, Evelyn Collins. Evelyn is coming to you via a pre-recorded video, and Evelyn is really going to set the scene for today's event and to give you a little bit more information on our agenda for this morning. So thank you, and over to Evelyn.
Good morning, everyone. Welcome to our first annual online employer equality update, online for obvious reasons relating to the public health advice in the context of the COVID pandemic. Now, while we don't have the usual opportunities we'll have for networking over the coffee break or over the lunch break, we do have all the essentials on equality law that employers and human resource professionals need to know, and thanks to our colleagues in the Labour Relations Agency, we also have up-to-date information on employment law. So I really hope that you'll find this session both helpful and informative. We're planning to run it again, actually, so if any of your colleagues weren't able to join us this morning, if there's a demand, we'll certainly try to meet that. So please let us know, contacting us whether by phone, by email, or by Twitter, Facebook, LinkedIn, or Instagram. Now, this morning there is a very busy programme to get through. We have two presentations and an opportunity at the end to ask questions. My colleague Paul Oakes will deliver the first presentation, looking at what developments in equality law this year mean for employers. And the second presentation will be by Mark McAllister of the Labour Relations Agency. We're very pleased to be working in partnership with the LRA again this year on this annual event, and I'd like to thank Mark in advance for his input. The presentations will provide you with an update of the key equality and related employment law issues and case law from the last 12 months. The event overall aims to increase your awareness of developments in equality and employment law and explain how you can best respond to these. Some of these examples provided to illustrate the legal points include recent and local cases in Northern Ireland, including, for example, a very important Court of Appeal judgment in British Telecom versus Kevin Mayer, a disability discrimination case which has implications for anyone using online recruitment. Now, as I've said, there will be an opportunity to ask questions at the end of the morning, but if you can't get your question answered today, or you'd like to ask it privately, don't forget we have an employer advice line. This event is by way of a review of the past year. When it comes to reviewing the current year, of course, things will be very different. We know that the COVID-19 pandemic has dramatically changed the employment landscape and given employers a vast and very, very different and new range of challenges. Just keeping your business operational is the top of everyone's agenda, and we acknowledge the strain on employers caused by the pandemic. by furlough arrangements, by having to consider different ways of working, and perhaps downsizing by having to make redundancies. While the environment in which we're all working has changed, the laws have not. Employees have the same employment equality rights that they had last year. Our advice and guidance on employment issues, even the really difficult ones such as selection for redundancy, still apply, and our advice and compliance staff are available to help advise and support you. We've had anti-discrimination legislation here in Northern Ireland for over 40 years, you know. In that time, Northern Ireland employers have played a very key role in implementing those equality laws, helping to create more equal workplaces, which are often the first place where people meet someone from a different background. A diverse and inclusive workplace helps break down barriers about difference and really encourages positive attitudes and relationships. So it's essential that you ensure you have the right advice and tools to operate within Northern Ireland's equality laws. And that's a large part of the Commission's work to support you in that. We've developed a single page on our website that links you to all the advice we've issued in relation to the pandemic. It's wide-ranging and practical advice, but if you don't see your answer there, or you don't see the answer to the question you're looking for there, please just ask. And as you will know, we've allowed extra time this year for employers to submit their Fair Employment Monitoring returns, reflecting these most extraordinary times. The advice and compliance team are pretty adept now at doing their employment training sessions online. They've concentrated all the content into a much shorter session, so you can get all the essentials you need in less than an hour without having to travel anywhere. There are also some COVID-specific short videos on the COVID page, which you can access at any time. We also issue a free employer e-zine to more than 4,000 employers with news and updates, especially on perennially useful things like our equality training. If you don't receive the newsletter, please use the chat on today's event to leave your name, organisation and email address to be added to our mailing list, or you can join from the link in the black banner on the bottom of every page of our website. Our advice line for employers is open from 9 a.m. to 5 p.m. Monday to Friday. And in addition, there's a wealth of information to assist you on our website in the dedicated section for employers. Please don't forget, we are here to help whenever we can. So now I want to hand over to Paul and Mark. I hope you find this session useful and thought-provoking. Thanks again for your attendance and attention, and I wish you all well in these difficult times. I trust that you and your colleagues, and indeed your families, stay safe. Thank you.
Thank you very much, Evelyn. And as Evelyn has said, we are acutely aware that these are really challenging times for employers. And our focus really since March has been on ensuring that we can continue to provide our services during these challenging times. So with this in mind, I would like to now hand over to my colleague, Paul Oakes from the Advisory Services team. Paul is Advisory Services Manager and is going to be discussing several key anti-discrimination cases and settlements, all of which have taken place during the past 12 months. And Paul's focus really when looking at these cases and settlements will be on the key learning points for you as the employer and really our recommendations in terms of the practical steps that employers can take to comply with anti-discrimination law. So thank you, and over to Paul.
Great, thank you very much, Roisin, for the introduction, and everybody, you're very welcome to this morning's session. As I go through the cases, we will examine the basic facts of each case, not in great detail, but we'll also look at the key learning points for employers. I won't do that with every case because it would be repetition, but I will do it for some cases. And for those cases that I don't provide learning points for as I go through the presentation, I'll summarize the learning points at the end. But as an employer, and we know from employers who've come to our employer updates in the past, there's generally 5 ways in which employers get something out of these sessions, and I'll go through them for you very briefly. First of all, some employers will find their awareness is raised about certain issues, that things that are happening or have happened in their workplace, they become aware perhaps are discriminatory or have negative consequences that they haven't anticipated. So you may find that your awareness has been raised and you may feel the need therefore to do something proactive in your workplace to address any issues of relevance. The second way you may learn is that you will become aware of the specific role that supervisory and managerial staff have within your organization. Because many of the problems that occur in the case I'm going to talk to you about happen because supervisory staff are not aware of policies, or they don't implement the policy effectively, or they don't regulate the behavior of some of their staff. So you might find that you need to do something in relation to your supervisory staff in terms of training. And the third type of learning is you might find, particularly from 2 of the cases, that there's a need for you to regulate the behaviour of some staff. And that is not meant to be fascistic and to say you need to control everything that your staff say. But there are occasions still in 2020 where staff used language which is completely unacceptable and which most people would know is likely to be a form of harassment, but they're still doing it, and employers on occasion are letting them do it. And so you may find for you that you have to begin to regulate staff behaviour. The fourth type of learning is it may hit you literally as I go through the session that you need to develop a new policy in relation to a particular issue, maybe, for example, on pregnancy and maternity. Or finally, whilst you may not need to develop a new policy, you might need to review your existing policy, practice and procedure. And here's the good news. We can help you with all of those through the ways in which Evelyn has outlined. So let's move on to, I suppose, the issue of the year on my next slide. It would be remiss of me not to talk very briefly about the impact of COVID and to mention to you what have been the big issues that we've had to deal with in terms of advice for employers. Well, in no order of priority, on the slide there are 5 of those issues. And the first issue relates to the impact on gender equality and on working families. And that's tied into the second point, which relates to those with caring responsibilities. A survey conducted by a GB charity called Working Parents suggested that 1 in 5 working parents feel they have been treated unfairly by their employer, that they have experienced significant problems in managing their work life and their family life. And we've found ourselves addressing quite a significant number of queries in relation to that. And in fact, this charity has suggested that those with caring responsibilities become a protected equality category. In relation to carers in particular, we still know that in Northern Ireland, women still provide 78% of caring responsibilities for young people and 79% for older people. So with the burden, if one wants to call it that, of childcare and the problem of managing care and work falls significantly more on women than men. And we know that women have been struggling in particular to combine these responsibilities. And that's why we've said to employers that where they're cognizant that this is going to be an issue, they need to deal with it in an empathetic way and talk to the employers concerned early and look at flexible working and other ways in which employees, predominantly women, can combine their different responsibilities in life and work. The third area which has been an issue is in relation to pregnant employees, and pregnant employees are included within the government's group of clinically vulnerable people. And it's important that employers recognise that in relation to pregnant workers, that they must conduct health and safety assessments in relation to specific pregnant women's scenarios, and it's not enough for them to do a generic assessment of the workplace. And this was highlighted in the case of Romas versus Gallego of 2017. And that's an important piece of advice for employers when they are managing pregnant employees. We've also had to advise employers on the need to ensure that those employees who are breastfeeding enjoy equality of opportunity, and specific arrangements are made in the workplace for those employees. Now, disability has been a significant issue over the last 9 or 10 months. And apart from the protections for disabled people in the DDA, the government's guidance basically introduced terms of clinically extremely vulnerable and clinically vulnerable. And the clinically extremely vulnerable and vulnerable are two groups of people that are likely to be afforded protection under the DDA. The clinically extremely vulnerable were people who were most likely to have been shielding during the early phase of the pandemic. But the clinically vulnerable group, they would compose generally of, for example, pregnant women, people over 70, people with chronic conditions like diabetes or lung conditions, and also, interestingly, people with a BMI over 40. Now, in that context, it's important to remember the Danish case of Kaltoft versus Commerons Landstring, which noted that although weight was not a disability as such, that in certain circumstances it would be considered as a disability. And therefore, it's important that employers bear that in mind as we move through the pandemic. And finally, we had to and have had to emphasise to employers to take the learning from the McKeith case. This was the McKeith against the Ardoyne Community Association of several years ago, in which the association engaged in prohibited activity. It engaged in associative disability discrimination. So it discriminated against a mother who had caring responsibilities for a disabled child. And whilst the DDA doesn't place a reasonable adjustment duty on employers in relation to carers of disabled people, the DDA does not allow those carers to be discriminated against directly or harassed by virtue of their caring responsibilities. So that's a brief summary of the main issues that have arisen in the last 9 months, and are still ongoing as hopefully we come out the other side of COVID. But I want to move on, and I want to look at the case law which Roisin alluded to earlier on. And I'm going to look at a range of cases in the time available to me. And I'm going to look at issues which will cover, for example, pregnancy discrimination, harassment, trans issues, discrimination in relation to service provision, disability discrimination, racial harassment, and flexible working. And as I say, what I'm going to do, I'm going to briefly give you the details of the case. And in most of them, I will outline the learning points. And for those that I don't outline the learning points, I will provide a summary at the end. I don't want to be repeating myself, and I'm sure you don't want me to do that either. So let's look at the first case. And this is an interesting case, which arose in 2018. And it concerns a lady called Laura Grusdate, and both her and her husband applied for a job with the McGrain nurseries in Tandragate, and they both were employed. They received a contract with no details on it, so there was no start date, there was no finish date. Ms. Gruesdate became pregnant, and she attended her antenatal appointments, and she told her immediate line manager of that. He did not pass that information on to the owner of the business. When she returned from her antenatal classes, she was quizzed as to where she had been and would she need more antenatal appointments, would she need more time off. So the questions that were asked were unsuitable, and they were not asked in a way that was conducive to a cooperative working arrangement. And they made Ms. Gruesdate feel very uncomfortable. Some weeks after, some temporary staff were let go. Some were kept on, but both Ms. Gruesdate and her husband were let go. And she took a case. And in taking her case, the tribunal noted that they believed she had been let go by virtue of her pregnancy and her attendance at the antenatal appointments. And this was found to be pregnancy discrimination, which is, of course, not justifiable. The tribunal also noted, which is sometimes forgotten, the traumatizing impact of this treatment. So that the learning points from this are fairly simple. One, did the employer have a policy? Two, did they implement the policy? The answer would presumably have been no. Were staff and management made aware of the legal requirements of pregnancy and maternity? If they had, they would not have asked the probing questions in relation to antenatal appointments. So that's an overview of that particular case. And then I want to move on to the next case, which is, again, this case relates to sex and concerns a teacher and concerns the part-time employment of this teacher. So Ms. McCormack was a teacher of English in a school, and she went off, she had her first child, and she came back to work, and she decided she wanted to work part-time for a temporary period of time in relation to her caring responsibilities. In that period, when she began to work part-time, a job came up as head of department. She was not considered for that job. A full-time colleague was appointed. Now, Ms. McCormack took a case, a sex discrimination case, indirect discrimination, on the basis that she was a part-time worker, and she was successful. Well, she took the case. The case was settled, but she was awarded £5,000. So what's the learning point from this? Well, first of all, this concerns indirect discrimination. And where an employer implements a principle or a criterion or practice which they feel is neutral, that they must be aware of the indirect impact of those principle, criterion or practice. What is the outworkings of those? And in this case, clearly, the employer made assumptions about Ms. McCormack. She was working part-time. Their assumption was, well, she wouldn't be interested in a full-time job. And that was an incorrect, stereotypical assumption. And secondly, by not considering part-time workers, by implementing that sort of blunt criterion, the indirect impact of that was to discriminate against women. Why? Because women are much more likely to work part-time than men. In fact, 39% of women work part-time and only 9% of men work part-time. So this introduction of a neutral or apparently neutral provision can lead to discrimination, and employers need to consider that. And we'll touch on this in later cases. So let's move on to the next case. And this is a slight jump. This is looking at the provision of services, but we can learn a lot from this in the employment context. And this concerned a letting agent, and this letting agent had a policy whereby they would not rent properties to people who were on benefits. Now, again, that's a fairly broad principle, criterion. It doesn't appear at first glance to discriminate against any particular group. However, the reality is that women, particularly single mothers with children, but women and disabled people are much more likely to be on benefit than other groups. And from the perspective of a woman, the impact of this type of policy can be to indirectly impact on women, and therefore this can be regarded as indirectly discriminatory. And this reiterates the point in the previous case. And from an Equality Commission perspective, you can't overstate the importance of employers when they implement a apparently neutral provision, that it may actually have indirect discriminatory effects. So think through the impact of the policy that you're implementing. So we'll move on now to the next case, which is perhaps the most complex of the cases that I'm going to talk to you about. It's a very interesting case in that it involves age discrimination, and that's why we've included it. This case, and I'm going to give you the briefest of details, this concerns judges and firefighters. So the judges took a case under McLeod and the firefighters under Sargent, and it concerned the government's pension reforms from 2015. And the government introduced transitional arrangements for those people who were members of existing pension schemes. And if you were an individual, broadly speaking, who was within 10 years of retirement, you effectively remained under the benefits of the existing scheme. Other people were moved into the new scheme, and the benefits overall, the net benefits were lower under the new scheme. So the impact essentially was that those within 10 years of retirement benefited, broadly speaking, and those within 10 years of retirement would tend to be older people. So the case was taken, or the two cases were taken, and interestingly, under age discrimination, as you may know, both direct discrimination and indirect discrimination can be justified. Indirect discrimination more easily, in a sense, than direct, if it relates to national, social, economic and political government policy objectives. However, in this case, the Court of Appeal said that the government had failed to show that the policy implemented in relation to the transitional arrangements was a proportionate means of achieving a legitimate aim. The aim was to reduce public expenditure in relation to pensions. But the Court of Appeal said that this was not a proportionate means of achieving a legitimate aim, and therefore it was not justifiable, and therefore it was direct age discrimination. Interestingly as well, in relation to the judge's case, not the firefighters, it was also found to be indirectly discriminatory on the basis of race and sex. And that was because from a perspective of sex and race, that the provision that you had to be within 10 years of retirement, that disproportionately women and people from Black minority ethnic communities were much less likely to be part of that category than, for example, men or people from white Indigenous communities. So it was found, the policy was found to be indirectly discriminatory, both in relation to sex and race. But interestingly, that wasn't found in relation to firefighters. But from a Northern Ireland perspective, the learning from this case has been taken on board. And as we speak, for example, the Department of Finance are considering these judgments in the context of Northern Ireland and how they might be implemented in Northern Ireland. So this slide, which is now in front of you, gives you a brief resume of the main points from the case. So I then want to move on to the next case, which is again, this is an age case, very simple case, which is reminiscent of the McGregor case. And one would think in 2018, when this happened, this would not happen anymore. But in this case, Mr. Mathieu applied for a job with a company. He went along for an interview, and the employer said to him that they were looking for someone they could train up and who could maybe move up into the office. So Mr. Mathieu, who was 63, said, well, is there any point in me continuing with my application? And the employer said, no. And this was judged to be direct age discrimination. The learning points are very clear, that employers need to know the law. They should have a policy in relation to issues like this, and that employees need to be trained so that they ensure that they comply with the legislation and they don't make decisions like this. Also, employers need to have a good recruitment and selection decision, which is based upon objective criteria. So an interesting case. It's here because one would think this does not happen anymore, but it does, and employers need to protect themselves against that eventuality. So we're going to move on then to another age case, and this concerns a lady, Ms. Walsh, who worked for a company, a pharmacy basically, and she applied and was given her job at the age of 60. From day one, she was teased about memory loss and about not being able to hear, and she was picked up for basic errors that other staff were not picked up for. She complained about the treatment, which eventually led her to go to her GP and to take antidepressants. And the director of the pharmacy said, you should just let the comments from the junior staff go over your head. Eventually, her own line manager, who was 24, asked her when she was going to retire. And the case developed to a situation where eventually Ms. Walsh had a fall. She had arthritis, she had a fall, she had to take time off work. And the director of the pharmacy said that's the final straw, and she was sacked. Now, the learning from this, and this obviously was a case of direct age discrimination. Also, disability discrimination was founded as well, and failure to make reasonable adjustments. But in terms of the age issue, this highlights the need to train supervisors and managers, because the manager should not have asked her when she was due to retire, particularly in the manner that he did, because at that particular time, the workforce had become increasingly hostile from Miss Walsh's perspective. Also, when she raised her complaint, it should have been investigated through the employer's grievance and disciplinary procedure. And interestingly, one of the findings in a number of the GB cases has been that employers have been fined extra money because they have not adhered to the ACAS code of practice on discipline and grievance. So this is a case again where employers need to regulate the behaviour of their staff, need to train their supervisors and managers, and need to comply with their own grievance and disciplinary procedure. So we're going to move on now to a very, in many ways, a groundbreaking case. Again, one would think this would not happen in 2019, which is when it did initially happen. This concerned a Polish person who worked in a restaurant called Sizzlers in Belfast. And again, from day one, he was harassed by a member of staff who made racist comments to him, slammed a fridge door on his hand. He made a complaint. It was investigated. The problem was that he was not told about the outcome of the investigation. The perpetrator had been suspended, come back to work. The Polish man did not understand why, because he didn't know the investigation had been completed. the individual who engaged in the racist behaviour continued to say to her employer, that she would not stop saying the things that she was saying to the Polish employee. And that's quite extraordinary, because here's an employee making racist comments. The employer accepts their racist comments, in fact, issued the employee with a final written warning, but didn't do anything to prevent her and allowed her to say that she would continue to engage in this behaviour. Not surprisingly, this was found to be race discrimination and racial harassment. And this is an example of where an employer needs to regulate the behaviour of their staff, that you cannot simply allow staff to behave in any way which they want, whilst leaving the company exposed to very significant financial and reputational risk. So now we're going to move on to a case which Evelyn mentioned in her introduction, and this concerned Mr. Meyer, who applied for a job as a graduate trainee with BT. Now, interestingly, with his application form, he indicated that he had autism. He actually indicated that he indicated a previous case that had been taken, Brooks versus Government Legal Services, where the employer had used an online situational awareness test, which had been found to be discriminatory against disabled people, and where the employer had failed to make a reasonable adjustment. So he was actually informing the employer of his own autism. He was aware that he would have to complete an online test as part of the application, but he had pre-warned the employer that this could be problematic. What happened in this case was that the information concerning his disability was never sent to the panel, or the panel did not receive the information. In this particular case, BT had a guaranteed interview scheme for disabled people, applicants who met the minimum criteria, but because the panel were not alerted to the disability, that fell through. So BT was found to not have complied with their own policy and not to have implemented a reasonable adjustment policy. But what's also interesting here is the use of online tests. And we increasingly see online tests being used by employers, and sometimes it's extremely difficult to see how the test is assessing the competencies that the employer intends them to assess. There's a disjoint between the test and the competencies needed for the job, and that's something we want to make employers aware of. If you're using online tests, one, be cognizant of the need to make a reasonable adjustment, but two, also ensure that the test is testing what it's supposed to test. Seems very intuitive, but it's something that employers need to do. So I'm going to move on now to a case of race harassment, and this concerns service provision as well, and it has ramifications for employment. This concerns Mr. Wong and his wife, and they went to buy a car, John Mulholland Motors. They were going to trade their own car in and buy a new car. In the interim, they decided to sell their own car, and they went along to Mulholland Motors to get the new car. Because they weren't trading their own car in, they had to renegotiate the finances. And Mr. Wong talked to his wife in Cantonese. He was explaining the finance arrangement and what they were getting themselves into. The staff asked and suggested that Mr. Wong and Mrs. Wong talk in English. Now, and they suggested this several times. And this is despite the fact that Mr. and Mrs. Wong were talking about the financial implications for them. And Mr. Wong refused on the basis that Cantonese was his wife's first language. She didn't understand some of the technicalities in English, and she needed to converse in Cantonese. And as the situation developed, Mr. Wong said that the atmosphere became quite cool and hostile. And at the end of the purchase, there was no shaking of hands, for example, as there normally would be in a situation like that. Now, this was found to be racial harassment. And the principle here again is the need to make staff aware of the legislation and aware of the need to create an inclusive, welcoming working environment, and to remember that that responsibility extends into service provision. It's not just in an employment context. So a basic case, again, one would think unlikely to happen, but did. The next case concerns pregnancy and redundancy. And in this situation, which concerned the Ritz Hotel, a redundancy situation arose, and staff were interviewed in relation to the redundancy. There was no criteria for redundancy. Staff were simply interviewed, and as a result of that process, a female was made redundant. In the context that there was a new post available in the Middle East, but the female candidate for redundancy, she went for that post with a male colleague, and she was not successful. Now, this happened in the context of the chief executive saying that the company was reluctant to bring women employees to the Middle East. So that had happened. So the female employee and the male employee both went for the job in the Middle East, but the interview process and the interview meeting that they had with senior management also turned into a discussion on redundancy. And the female concerned, Taylor Hamay, felt that she had been discriminated against by virtue of her sex, and she won her case. And the part of the reason for her winning her case, to some extent, the senior manager's comment, but the fact that there was no record of the interview meeting or the redundancy discussion. There were no objective criteria on which the application process was conducted. There was no rationale for why the male employee had been given the job in the Middle East. There was no justification. There was no record of the scoring criteria or anything like that. And that allowed the tribunal to make an inference that this was a case of sex discrimination. The learning point is the need again to have objective recruitment processes, to use objective criteria, to keep records, and also for senior management to be cognizant of what they say and how they behave in the workplace. So let's move on to a slightly different topic. And again, this slide is here, again, because it will resonate with those of you who've been in the equality field for quite some time. And this is a case, a race case, and a case of racial discrimination. And this concerns a employment agency. And this employment agency, which was Element Personnel Services, in 2019 was responsible for recruiting staff to five-star hotels like the Dorchester in Mayfair and Claridge's. And the individual who took the case felt that the individual who took the case was a Sikh and for religious purposes wore a beard. But the employment agency did not consider him for a role in Claridge's or Selfridge's, or in the Dorchester or in Claridge's. They refused to do so. And they did this without asking the Dorchester or Claridge's, but they did it because these hotels had a policy that employees had to be clean shaven for appearance purposes. So Mr. Sethi, who was the Sikh applicant, took a case, and it was found that he was discriminated against on the basis of his race. What was interesting is the tribunal said that the personnel company, should have asked the Dorchester if they would make a revision to their policy based upon Mr. Sethi's religious beliefs, but they didn't. And it's likely that they would have to have made this amendment in reality because the justification for the no beard policy was simply based on image. It was not based on health and safety reasons. Had it been based on health and safety reasons, it could have been justifiable to have such a policy. and we bring you back in that situation to the ASME versus Kirklees Metropolitan Borough Council case, in which the justification was pivotal to the decision in that case. So let's move on to another case, which is it concerns, it's probably the first time actually that the Court of Appeal will consider a Christian freedom of speech case, and the case is actually still ongoing. But in this particular case, Mr. Page was a magistrate, and he had made negative comments about same-sex adoption. He'd been opposed to it. Not only did he have those views, but he went onto the BBC and he went onto social media, and he was removed as a magistrate, and he took a case of indirect discrimination on the grounds of his religious belief. And he was not successful. And the reason he was not successful is the tribunal decision was he'd lost his position, not because of his religious beliefs, but because of the manner in which he'd expressed those beliefs, which was he went to the media. He didn't engage with his employer prior to going public with his comments. Now, this case has been appealed. It only commenced in November 2020, and we're awaiting the decision of that with some interest, and we'll keep you updated in relation to it. So I'm going to move on. I think I have 3 minutes left, so I don't have much time. But I'm going to tell you about this case because this is perhaps one of the worst cases that we're going to look at today. It concerned an engineer, Mr. Allen, and he was in a same-sex relationship, and his intention was to go for a senior position as general manager, and he was being promoted and pushed by the company, and basically things began to go sour when he came out as being gay. And comments were made, and homophobic comments were made in the workplace. And the HR manager, for example, said to him that they couldn't have a general manager who intended being off for a 12-month period as a result of gay adoption. And Mr. Allen and his partner were about to adopt. So the company had said that wouldn't be acceptable if they had a general manager who was going to take that amount of time off. Of course, the question is there as to whether they would have said that if that was a male and female couple who were adopting. However, the comments, the homophobic nature of the comments were acerbic. And Mr. Allen did not get the job as general manager when he applied for it. The working environment became increasingly cold, and he felt isolated. And he took a case, and he was successful and was awarded £175,000. And basically, the tribunal found that he was discriminated against. He suffered a detriment because he intended taking adoption leave, and his sexuality was a factor in that decision. So again, this case resonates in terms of the need to ensure supervisory staff are aware of the law, aware of an employer policy, ensure the employer has a policy, and ensure that staff are trained. So let's move on. This case, which I'm going to look at, in fact, the next two cases, and then that will bring me to a close. This case concerns a trans person, Ms. Moore, who applied for a job in Debenhams in Newry, and she was not successful. And the employer said that she wasn't successful because they needed somebody who could work over 16 hours a week. Now, she basically was not able to work over 16 hours a week because of issues around benefits. However, it transpired that Debenhams had appointed people on contracts of 14 hours a week and less. And hence the question was, well, in that case, why not give Ms. Moore one of those contracts? But they didn't. And the result of that was that the case was settled in relation to the Ms. Moore's claim. And it then brings us on to the next case, which is in many ways, a groundbreaking case. Now, it is important to say that this case is a case that went through the English and the Welsh courts, so it doesn't have direct ramifications that we are aware of yet. But why it's important from a trans perspective is this, that under the Equality Act and our own legislation, gender traditionally is seen as something that's binary. You're male or you're female. And the protection afforded to a trans person exists when they go through or they're going through a gender reassignment process. In this case, however, the tribunal suggested that the protection be extended to those people who are non-binary, so who are going through the process as distinct from have reached the end of the process. So this is important because it means that protection is afforded to those people who are within the fluidity of that process, that they do not have to have gone through the process and reach the end of that process. And it is something that's important for employers to take on board. And in a practical sense, it probably means that employers need to be considering the language which is used in the workplace, and they need to be ensuring that trans people are addressed by terminology, pronouns that they feel is appropriate. And that is of primary importance. And you possibly note that this decision has already been taken by the Northern Ireland Civil Service in recent days. So although it doesn't have direct ramifications for Northern Ireland yet, because the decision is not binding, it is something for employers to take on board in terms of their own practices and procedures and their own policy in relation to the workplace. So let's move on. And this is my final slide, and we're looking at projected developments, predicted developments. Now, the difficulty this year is that traditionally in the past, this has been a 15-minute section of the talk. Today, it's not, because in terms of predicted developments in the equality field, it's extremely difficult to predict with any certainty what is going to happen in the medium term. Of course, there's Brexit, and the implementation period that's been agreed under the initial agreement ends on the 31st of December, and Brexit comes into effect on the 1st of January, and that's subject to any further agreements that may happen as a result of the discussions which are going on today. And we don't know. We will need to await the result of those discussions. Secondly, gender pay reporting. This is something that we've already alluded to repeatedly. It's not clear to us whether we will see the introduction of regulations in relation to gender pay reporting, or indeed in relation to the proposed race or disability provisions of gender pay reporting. It's something we're keeping an eye on, a close eye on, and we will update employers as that information becomes available. And I suppose finally, and this is because people ask us this question, there is no sight at this stage of a single Equality Act to replicate the Equality Act in GB that we can see, although we continue to push for that. But again, it's something that we will update you about as we become aware of developments. And I finally want to leave you with two slides, and I'm not going to go through these, but these simply outline the range of support that's available from the Commission and the contact details that are there. And the reason they're there is, if after today there's anything that I've said in my very quick run through, please contact us and we would be delighted to provide additional clarification and support in relation to any of those issues. So thank you for listening. There may be one or two questions which my colleague Roisin is going to field through. Roisin?
Yes, Paul, thank you very much for that really detailed and interesting presentation. We do have some questions, some great questions from attendees. The first one that we have, Paul, is will will online Christmas parties be still subject to equality law?
Yes. It's the very simple answer. Yes is the very simple answer. And in fact, as I mentioned that, Roisin, I was trying to recall a case. I think it was the teletext case going back to 2013, where this was an individual who used social media to harass another employee. And basically, he thought that by using social media in his own home, outside of the workplace, that basically it was his own piece of equipment, it was his own home, and therefore that was quite an acceptable thing to do. He wasn't at work. Well, the tribunal said that it wasn't acceptable. And in fact, he was found to have harassed another employee, because it was clear from the assertions that he made who he was harassing, and it was been done in the context of them working in the same organization. So don't assume online, you're in your own house, you're using your own computer, that it's carte blanche, you can do what you like. You cannot do what you like. The workplace policy of your employer still applies. So you need to make sure you warn staff, as traditionally we've advised, that they should regulate their behavior, they should comply with the employer's policy. They need to wear appropriate clothing. They need to be cognizant of any emblems that are visible if they're at home. It wouldn't be a good idea to be sitting at home having a chat with your colleagues from work with a big flag in the background and several emblems. Also, you need to be sensible again in the terms of the language you use to your colleagues, and careful of using any language which might make people feel unduly uncomfortable or threatened. And also, we always put the rider in terms of where does the most of the bad behavior originate from. Unfortunately, it tends to be alcohol. So just be cognizant of maybe warning your employees that they're still in a working environment and that they're subject to the employer's policies, Roisin.
Brilliant. Thank you very much, Paul. And just to clarify for any employers, as Paul said, that was the Teletech case. It's a case called Teggart versus Teletech from 2012 in the Industrial Tribunal. So thank you for that, Paul. Another question, what should an employer be considering when recruiting solely online?
Well, we wouldn't advise employers to rely on solely in terms of online recruitment. And certainly with some of the online recruitment we see, we would have significant concerns with. For example, we see some online recruitment where if you don't fill in the monitoring form completely, you're denied a chance to apply for the job. That's not right. For example, if you don't fill in all of the monitoring questions, then your application is dismissed. That's not acceptable. That's bad practice. So maybe looking at that a bit further, online applications, they don't always suit everybody. Not everybody is as competent using computers. In fact, not everybody has access to online or computers. And it's interesting to note one of the banks acknowledged that. And what it did was it allowed people to recruit online, but you could come into their branch and use one of their computers and apply online if you wanted to do that. And you could get help in doing it if you weren't computer literate. Also, it can potentially be problematic for people from Black minority ethnic communities, perhaps whose first language is not English, to rely solely on online recruitment. So you need to consider, again, this is going back to the point of indirect discrimination. It might appear to an employer that if you use online recruitment for everybody, that's okay. But you've got to think about the outworkings of that, and who that may make feel less advantaged. And then you should be thinking of facilitating those people to allow them to apply for the job. And certainly from a disability perspective, there are some people with certain disabilities who will not be able to give the best account of themselves through an online form. And you must, in that situation, consider reasonable adjustments, which would allow them to use a methodology that gave them an equal chance to other candidates. The final thing I'd say, Roisin, is with some online recruitment, what bothers us as well is that the applications go to a fairly limited number of people on occasion. And you need to be careful in respect of that if you use online to promote your job, is it going to a narrow group of people, or is it going to a broad group of people who would be able to apply for that job? So just be cognizant of issues like that. Okay, thank you, Roisin.
Paul, thank you very much. Paul, I have just one final question for you before we wrap up this part of the session. And that question is regarding disability and reasonable adjustments. So how should an employer make a reasonable adjustment during COVID for a person who is returning to the workplace?
Well, let's, for example, think about that, and let's just take COVID out of it for a wee second. What's the first thing you always do when you're considering a reasonable adjustment? You talk to the person with the disability. The worst thing an employer can do is try and second guess what reasonable adjustment will accommodate or best accommodate a disabled person. That's a mistake. And so the first thing you do, and you always do, is you talk to the disabled person, and remembering, of course, with a reasonable adjustment, what you're required to do is to reduce the substantial negative impact. So therefore you ask the person, because they're the individual who will have learned to accommodate, live with their disability. So talk to the person with the disability. I would say to you, don't make assumptions about reasonable adjustments. Some people assume they cost lots of money. They don't. Over half of them cost nothing, and 78% of them cost less than £50. So reasonable adjustments don't, in general, cost very much, if anything. So don't let yourself be tied up with stereotypical assumptions that are wrong. So that's the second point. So having talked to the disabled person, agree the reasonable adjustments that you're going to make. And make sure you monitor them, because you want to make sure they work. Because if they don't work, there's no point in keeping on doing them. So identify them, put them in, evaluate them, and see if they work. And evaluate them over time, because disabilities don't stay static. Some of them do, but a lot of them don't. They change over time. So you need to be thinking regularly about what changes and adjustments you can make to them. Also think about involving occupational health if that's going to provide a positive input. Then also think about the government's access to work scheme. Think about the support that is available to employers from the government, Department of Communities, to make reasonable adjustments for disabled people, because it might be that they can offer you some financial support. And also, I suppose the last point is we also know that all disabilities are not the same, that people with mental health disabilities are, if you like, the bottom of the pile because of the stereotypes, because of the stigma. So if it's a mental health disability, think about signing up to the Commission's Mental Health Charter and get involved with the Mental Health Charter. Take advantage of the training that we do. And finally, when you're doing these reasonable adjustments, remember the purchasing power of disabled people. Remember that when you're seen to meet the needs of disabled employees, that can resonate with the people who buy your products. And there's reputational capital to be involved, as well as the legal requirement to make a reasonable adjustment.
Okay, thank you very much, Paul, for that really detailed and informative session. We are conscious that Paul has covered a wide range of equality issues there in a short time. So what we would say to employers listening today is please do feel free to contact us following today's session if we can be of any further help in terms of, I suppose, really translating these issues into practice within your own organisations. I would now like to welcome our third and final speaker for this morning, Mark McAllister, Director of Employment Relations from the Labour Relations Agency. And Mark has kindly agreed to spend the next 40 minutes or so taking us through his annual employer update to outline key employment issues that employers need to be aware of. And having attended similar sessions that Mark has delivered, as many of you have, too, I'm sure. I know you'll find this session both enjoyable and informative. So thank you, and over to Mark.
Roisin, thanks very much indeed, and you're all very, very welcome to this annual review of employment law, and thanks to Paul there for a really comprehensive session there. Thoroughly enjoyed that. So let's skip to the contents page because we are going to go through this at a whistle-stop pace. In order to ensure that everybody has enough information, Paul and his team will email each of the participants a narrative that's going to accompany this particular presentation. It runs to 54 pages long of narrative, so it's a fair bit of detail, but it'll drill down into some of the issues that I'm going to be skimming across here in the course of this morning. So we're going to take a look at the developments in 2020, retrospectively, look at the employment statutory rules, which is the main vehicle for employment law reform in Northern Ireland. We'll take a look at early conciliation, which has had which commenced in Northern Ireland on the 27th of January of this year. We'll look at some of the developments in GB in employment law, and it's important to remember that prior to 2020 we had around 23 or 24 substantive differences in employment law between Great Britain and Northern Ireland. That has now increased as a result of some of the developments in GB, and time permitting we'll take a look at a swift look at the top 10 cases for 2020, and we'll look forward into the crystal ball for 2021. So in terms of the backdrop to all of this, it's clear to see, and it's trite and a statement of the obvious, that everything is now being viewed through the prism of coronavirus. So in January 2020, most employers were getting ready for example, the implementation of early conciliation in January. They were also getting ready for things like changes to statutory sick pay, statutory maternity pay, changes in employment rights limits for things like redundancy pay and unfair dismissal compensation, which came into effect in April every year. So it's the old perennial. And then suddenly, in the middle of it, a global pandemic. And what that meant for many organizations was the overlaying of context-specific scenarios in the context of pre-existing employment law. So you had to look at statutory sick pay through the lens of coronavirus. You had to look at health and safety through the lens of coronavirus. You had to look at working time and holidays through the lens of coronavirus. So this, as Paul alluded to earlier on, employment law hadn't changed. The core principles of employment law coming into 2020 were exactly the same. This had just added an extra layer of complexity. So we've had in the last 9-10 months an absolute mishmash of primary employment law, secondary employment law, treasury guidance, public health guidance, etc. And it has been very, very confusing for employers to say, well, I'm not sure what I have to do in this context or that context or whatever. So what I'm going to try and do over the next sort of 20 minutes or so is to take a look at that and try to sort of demystify it to a certain extent. So if we take a look at, for example, at the statutory rules, as an overview, just to give you an idea, in Northern Ireland, we pass anywhere between 6 and 8 statutory rules every year relevant to employment law, which is not a great deal because employment law is devolved to Northern Ireland and we tend not to pass too many pieces of legislation. In 2020 alone, so far in the last 9 months, we've passed over 32 pieces of statutory rules which could impact on the employment relationship. We've also had commencement order number 3 of the Employment Act Northern Ireland 2016, which was the vehicle for bringing in early conciliation, and as a result there were 4 early conciliation related reforms to the legislation to allow the legislation to bed in for things like time limits for submitting claims to an industrial tribunal. And then there was a raft of reforms to statutory sick pay, a week's pay for the purposes of calculating remedies and limits. There was a reform to the national minimum wage, reforms in terms of carrying over leave, limits and rates, which we're going to walk our way through now. So if we take a look at the next slide, and the important thing to remember is think of it as a funnel, okay? So you had the Coronavirus Act 2020, then you had a variety of these health protection coronavirus restrictions legislation, and then you had the specific employment laws. So that's the way I want you to think of it. So coronavirus, for example, the 2020 Act in Section 52 gave the ability to effectively close businesses. Okay, that had that power. It was also the vehicle for establishing furlough as we know it, and the ability for HMRC and the Treasury to produce guidance, which was effectively soft law, for want of a better word. So that's your overarching piece of legislation that effectively set the scene for closures and restrictions, etc., etc. Then we have now, as recently as last week, we have 18 sets of health protection coronavirus restrictions number 2 amendments. So you had amendment 2, 3, 4, 5, 6, 7, 8. And retrospectively, what we know, if you look at this legislation, it's very much a case of whether or not it was affected your particular industry. So for example, the health protection coronavirus restrictions number 2, amendment number 3, closed soft play areas. Okay. Amendment number 4 set the 6 persons from 2 households rule. Number 9, for example, set the sort of 4-week mini, as we talked about, the mini lockdown restrictions, and so on and so forth. So number 8, for example, was the restrictions that only related to the Derry and Strabane council area. So if you need to know why a particular industry like a bar or a particular business like a close contact, etc., is closed and the ramifications therein, what you need to do is go to the relevant health protection coronavirus restriction and see which one of the 18 sets of regulations applies to you. An absolute minefield of legislation, and very, very specific. And remember, lots of the confusion that's happened with regard to coronavirus and the restrictions is because this legislation has not had the chance to go through the normal checks and balances that we would associate with the passage of legislation. It had been rushed through because of the pandemic and the risk to life. So there was a balancing act, and that's why you'll always hear, the term about lives and livelihoods being referred to hand in glove. Then, more specifically, there were amendments to the statutory sick pay general coronavirus regulations. And what that did was effectively redefined what was meant by incapacity for work. And a lot of this was retrospective and backdated into March of 2020. So redefinitions of incapacity covered things like self-isolating, the suspension of the three-day waiting period. It defined extremely vulnerable people, clinically extremely vulnerable people, close contact provisions, self-isolating but a negative test under COVID, all of which was shoehorned into the statutory sick pay arrangements to allow people to be able to claim SSP because in some way they had been impacted by coronavirus. And it is not without its controversy, because many employers out there only have statutory sick pay provisions. They don't have occupational sick pay, and it can be difficult to live off £95 per week. So moving on, in terms of more specific pieces of legislation, then we saw the implementation of the Employment Rights Increase of Limits Order, Northern Ireland 2020. And this effectively happens every April. So this is a piece of legislation that is brought in that effectively says, okay, if you are making someone redundant and you're using the statutory redundancy scheme and the calculation, then the cap on a week's pay in terms of the maximum under statute is £560. So that figure changes and alternates every year. So a cap on a week's pay from the 6th of April 2020 stood at £560 for the purposes of calculating statutory redundancy pay or for unfair dismissal compensation computation. It increased the limit of guaranteed pay to £30, and the high limit of unfair dismissal compensation was amended to £88,693. And all of this is detailed in the narrative, so you don't have to worry about taking notes down here because it comes with the narrative. One of the most interesting amendments is the second one there on your screen. So the Working Time Coronavirus Amendment Regulations Northern Ireland 2020. And this was effectively about taking leave. One of the big controversies with regard to the approach to the pandemic was people weren't taking leave because obviously there were a vast array of restrictions in terms of destinations for people going on holiday, or whether they were self-isolating, or something happened that meant that they couldn't take their annual leave. And this became a real issue because the working time regulations, which regulate rest and holidays and things like that, effectively have a regulation under Regulation 15, which says that during the holiday year, you use it or lose it. This is, and there are a few exceptions to that, and things like long-term sickness mean that you can automatically carry over 4 weeks into the new holiday year. The Working Time Amendment regulations came along, recognised that coronavirus context was meant that people couldn't take their leave, so this disapplied Regulation 15. In other words, it said the use it or lose it rule doesn't apply anymore. So if it has not been reasonably practicable for a worker to take their leave as a result of the effects of coronavirus, and that could be the worker or the employer or the wider economy or society, then they are allowed to carry over leave, and that'll be the 4 weeks under the working time regulations, into the following 2 years. Now that's a significant development in employment law, because the general rule prior to this was use it or lose it. So the outworkings of this piece of legislation have yet to be realised, because we don't know how employers are going to have to manage their leave arrangements going forward for it. So, for example, in the aftermath of the last series of vaccinations that happened, is an employer going to face an absolute tsunami of holiday pay or holiday requests for time off? And that's going to have to be managed in the context of the existing legal framework. So we haven't seen that play out yet in the context of, well, what was meant by not being reasonably practicable to take your leave. How is the employer going to address leave requests in 2021 when the vaccination program is complete? So a lot of this is sitting there, but most employers need to be aware that obviously if people can't take their leave for coronavirus reason, they are allowed to carry over 4 weeks into the next 2 years. Okay, if we take a look at the next set of employment amendments, the Employment Rights Northern Ireland Order 1986 Coronavirus Calculation of Weeks Pay Regulations. Snappy title, but effectively what this piece of legislation does is that when you are calculating payments for things like notice pay and redundancy, there was a question mark over the 12-week backdating referencing period for such calculations. And if someone was furloughed, then employers were asking the question, so do you use the 12 weeks of their furlough because it's been furloughed for maybe 16 weeks? And the law was amended to say no. Effectively, when you are calculating various statutory entitlements based on a week's pay in relation to termination of contract, like redundancy or given notice, etc., the pay should not be reduced to the furlough level, i.e. the 80%. It should be on a normal week's pay based on what they would have got ordinarily, without looking at it through the lens of furlough. And that has recently been amended there last month in November, because the furlough scheme has been extended into 2021. So it's an important amendment to the calculation legislation there. National minimum wage regulations come into effect every April. We're quite used to them now. So in April, the adult rate changed up to £8.72 for the 25-year-old rate plus. For the 21 to 24-year-old rate, it increased to £8.20 per hour. For the 18 to 20-year-old rate, it increased to £6.45 an hour. The youth rate increased to £4.55 an hour, and the apprentice rate £4.35 an hour. The interesting thing to note is, up until about 2 weeks ago, there was a question mark hanging over what would happen to the national minimum wage regulations in 2021. So in the Republic of Ireland, they already moved about 6 weeks ago to indicate that from January 2021, the increase of the national minimum wage would increase to €10.20. whereas there was a question mark hanging over about the 2021 for the UK national minimum wage rate. That has now been answered, so we now know, and you may want to make note of this because this is a very recent development, it's not in the narrative notes. National minimum wage amendment regulations for April 2021 will mean that the living wage rate will apply to those 23 years of age plus instead of 25 plus, and it will be £8.91. The 21 to 22-year-old will increase in April to £8.36. The 18 to 20-year-old rate will increase to £6.56. The 16 to 17-year-old rate will increase to £4.62, and the apprentice rate will increase to £4.30. So that's roughly anywhere between a 1.7 and 2.2% increase in national minimum wage pending in April 2021. So be aware, it's not going to be suspended or frozen or whatever. Those increases averaging in around 2% will happen in April 2021. Second amendment there, the National Minimum Wage Amendment Regulations number 2, effectively applied to salaried staff. So it augmented and increased the certainly more complex rules on what we call payment cycles, where people are paid maybe every 2 weeks or 4 weeks to ensure that employers comply with national minimum wage provisions. Okay, moving on. The Social Security Benefits Operating Order Northern Ireland 2020 again happens every April. These are with regard to the well-known payments of things like statutory sick pay. So in April, statutory sick pay increased to £95.85 per week. Statutory maternity pay, shared parental pay, paternity pay increased to £151.20 and covered paternity, adoption and parental pay. And then there were a raft of technical amendments to ensure that statutory maternity pay, for example, again, female staff wouldn't suffer disadvantage, so that their SMP wouldn't be calculated on the basis of a furloughed rate of pay. So we had the maternity allowance and statutory maternity pay, normal weekly earnings, etc. Coronavirus Amendment Regulations 2020, and the statutory paternity pay, statutory adoption pay, statutory shared parental pay, normal weekly earnings, etc. Coronavirus Amendment Regulations Northern Ireland 2020, and they effectively ensured that people in those scenarios did not suffer a financial disadvantage by virtue of the fact that they were furloughed. Okay, and so those technical amendments were made. Okay, moving on. Prior to 2020, the only thing that was really on the minds of a lot of practitioners and organisations who are dealing with disputes in their work, etc., was the implementation of early conciliation. So it began in earnest on the 27th of January, which seems like an absolute lifetime ago now. And effectively, for those of you who are maybe not aware of this, but early conciliation effectively means that before an employee can lodge a claim to an industrial tribunal in Northern Ireland, they must have first considered the possibility of engaging in conciliation with my organisation, the Labour Relations Agency. And there is provision to effectively stop the clock, which is the sort of 3-month time limit that an individual has to lodge a claim with the tribunal, to allow us to facilitate conciliation between the employer and the employee with a view to resolving it. Now, it is a completely voluntary process, and the parties don't have to engage in the actual conciliation, but they must at least consider it. So they have to contact our organisation before they would even think about approaching the industrial tribunal. The context of all of this, unfortunately, has meant that in the context of coronavirus and things like holiday pay claims, there is a massive amount of cases that have been lodged between February and September of this year, 12,447 cases in total. Now, the vast majority of those are either redundancy-based related cases, and that's a reflection of the economic consequences of the pandemic, or they're with regard to holiday pay claims. Now, there is, and the only way to put it is, there is a tsunami of holiday pay cases pending before the Industrial Tribunal in Northern Ireland because of case law decisions in this area relevant to the working time regulations. And we'll talk about a wee bit about the Agnew case later on. But effectively, these cases have been lodged at the Industrial Tribunal to individuals and they have to reissue these cases to the Industrial Tribunal every 3 months because they're an ongoing unlawful deduction from wages, based upon the fact that the employer didn't calculate holiday pay correctly because they hadn't factored in regularly worked, regularly achieved overtime in their 12-week back referencing calculation. And that has been a major issue and feature of employment law over the last 5 or 6 years, which is now reaching a crescendo because the Agnew and PSNI case goes before the Supreme Court in June of 2021, where we will get a final answer with regard to where the case law sits. So if you take the redundancies and the holiday pay cases out of the equation, we have had 1,775 cases, individual cases, and anecdotally we certainly find that employers and employees are engaging. But we're not naive in the sense that we know that legislation is a very blunt instrument to affect a cultural change in an organisation. So in many instances, we have found that a call from the Labour Relations Agency sometimes comes unexpectedly to an organisation saying that employees wants to engage in conciliation because they're about to lodge a claim before the tribunal. And I think my response to that is if an employer is blindsided by a call from the Labour Relations Agency about an early conciliation claim, my first question is why? What does that say about the dispute resolution culture in the organisation? So, most employers will be well aware of who's lodging a grievance or who's been disciplined or who's been dismissed. So it shouldn't come as a total shock to an employer when an employee, when the agency contacts the employer to say, are you willing to engage in early conciliation? But that has happened. So I think there's a wee bit of inward looking and looking at the cultural impact of the dispute resolution culture in the organisation, in terms of disciplines and grievance and that inward focus, so that, we need to look at the reason why there is that sort of surprise culture in that regard. However, all of this has to be looked through the lens of coronavirus. So the Office of Industrial Tribunals and Fair Employment Tribunals closed, obviously, as a result of the pandemic. It reopened in October, and slowly but surely it started to go through a combination of virtual and real physical presence hearings. But there is a backlog. So there will be a massive backlog, and that will have an impact. The impact of COVID on the settlement culture will be significant. So we need to be aware of that, in the sense that some of the cases that are listed for hearing might well not be heard until maybe the tail end of 2021 because of the backlog. And so that will have an impact on whether or not parties decide to settle or not. So we have to be realistic about what the time frame is going to be involved here for employers who are defending a case to the tribunal. There will be a significant backlog of cases. Okay, moving on. As I said from the outset, employment law is devolved in Northern Ireland. So as a result, there is a significant amount of differences between employment law in GB and Northern Ireland. So at last count, I think there were around 23, 24 substantive differences in employment law between the two jurisdictions, and they cover everything from qualification period for unfair dismissal, differences in the law on TUPE, differences in the law in obviously in equality law, and a raft of other, some more technical than others, but there are around 24 substantive differences in the two jurisdictions as we currently stand. That is now increased to around 32 as a result of developments in GB during April, in and around April of this year in 2020. And I'm going to walk you through some of the more significant ones of these. So holiday pay reference period. At the minute in Northern Ireland, when you're calculating holiday pay, you calculate it based on the 12 preceding weeks from the holiday date for the holiday pay to be calculated. Now, that has been complicated by case law regarding things like overtime and bonuses, etc. And we've seen that happen over the last sort of 10 years. So in GB, rather than use the 12-week back referencing period, the law has been amended. The Employment Rights Act in GB is amended so that it uses a 52-week holiday pay calculation reference period, and that is effectively designed to smooth out the peaks and troughs in things like overtime and bonuses to allow an employer to properly calculate holiday pay. The difficulty in Northern Ireland, we still work to the 12-week back referencing period. So as a result of cases that we've discussed, like Agnew, and cases that we'll take a look at later on, like the Brazil case. So if you have a 0 hours worker in an organization who's entitled to holiday pay, who does a raft of overtime regularly, but in the 12 weeks coming up to their holiday period, they do lots and lots and lots of overtime. That means that you have to calculate those 12 weeks based on the lots and lots and lots of overtime, which means that someone who's on a 0 hours contract, as happened in the Brazil case, could effectively have holiday pay which would be far more than the holiday pay that you have for your employees in your organization. But that's the nature of the beast, in the sense that the case law has now dictated that you must factor in regularly achieved overtime based on the 12-week back referencing period. So in Northern Ireland, we still use the 12-week back referencing period, whereas in GB from April of this year, it's 52 weeks, and that is a significant difference, and that's to take account of cases like Agnew and Brazil and Harbour Trust and things like that. Also in GB from April, any worker, now it's important to make this distinction, it's not just employees, but workers in GB are entitled to receive a statement of written particulars from day one. Okay, that's an important distinction. In Northern Ireland, the written statement applies only to employees, and it has to be given within 8 weeks of commencing employment. Okay, that still is the case in Northern Ireland. So only employees are entitled to either a contract of employment or a statement of written particulars within 8 weeks of commencement, whereas in GB, workers or employees must receive a statement of written particulars from day one. Okay. The third point there is the Swedish derogation. Those of you who use agency staff will be aware that if you operate under a Swedish derogation principle, an agency worker will not be able to make a pay comparison with a full-time comparator in the organisation, or will not be able to use working time related parity rights against a full-time comparator in the organisation, because the Swedish derogation applies. Now in GB, that Swedish derogation has been abolished, but not so in Northern Ireland. So if you have an agency worker in Manchester currently goes into an organisation, they can make a pay parity argument against a proper full-time comparator from day one, and have working time related comparative rights as well. Whereas the equivalent agency worker in Belfast under a Swedish derogation cannot make those comparators because the Swedish derogation applies. So that's a very significant development, and quite a controversial one, because the Swedish derogation, when it came into effect in Northern Ireland back in 2011, was deemed to be, there are many commentators, like the trade union movement in Northern Ireland, said the Swedish derogation effectively runs a coaching horses through the rights of agency workers and should never have been agreed. Well, it has now been abolished in GB, but it hasn't been abolished in Northern Ireland, so it's important to be aware of that. So Swedish derogation agency arrangements still exist in Northern Ireland. And following on from that, in terms of agency workers must receive within 30 days of their appointment the type of contract that they have signed up to, the expected minimum rate of pay, how they'll be paid and by whom. And these are amendments to the GB Conduct of Employment Agencies and Employment Business Regulations. So that sort of requirement to have that contractual document is in place within 30 days of commencement of their placement. The information consultation regulations came into effect in Northern Ireland in 2005, and effectively this is an exercisable right for a certain percentage of staff to effectively ask the employer to begin to negotiate the mechanisms under which they engage with their staff to inform and consult. And there are three arrangements there. You can have what's called a PEA, which is a pre-existing agreement, which could have existed prior to 2005. You can have a negotiated agreement where the employer sits down with the employee reps and negotiates an information consultation arrangement for staff. Or you can have what's referred to as the standard default, where the employer must engage with staff and inform and consult on Category A, Category B, and Category C information. So that threshold in 2005 used to be 10% in GB. It's now reduced, so you only need 3% of staff in the organisation to trigger that information consultation request in GB, whereas in Northern Ireland, it's still a 10% request threshold. So there are some of the significant differences in GB that have happened in April 2020. So as I say, we're now running at somewhere in the region of 32 substantive differences in employment law between Northern Ireland and Great Britain. And given that it is a devolved matter, and given that we're in the mouth of Brexit, it'll be very interesting to see what way employment law policy develops in 2021, and we'll talk a wee bit about that later on. Okay, other changes then. The Department for the Economy are busy working away at the parental bereavement leave legislation in Great Britain. Although it was a 2018 Act, it came into effect in law in Great Britain in April of 2020. So you have provision for that in GB. In Northern Ireland, there has been a consultation process on implementing the parental bereavement leave legislation. We don't know what that looks like yet. It may be an exact mirror replica of the GB legislation, or it might be tweaked slightly to suit the Northern Ireland jurisdiction. We don't know yet, but that's certainly on the cards in the new year. There was an amendment to the Posted Workers Directive, which came into effect in GB in April and came into Northern Ireland in effect on the 13th of November. And this gives additional rights to posted workers because there's an obligation on the hirer to inform a temporary worker, a temporary work agency, of the posting of an agency worker. So there's a tweak to the Posted Workers Directives there under that. And in GB, just prior to the implementation of the just prior to the COVID pandemic, and so we're talking around sort of March, April time, there was a discussion about a new draft employment bill in GB, which covered key areas, things like the right to make flexible working the default position in an organisation with over 250 staff, to have a single enforcement body for things like national minimum wage and for vulnerable groups, the right for people who work on a trunk tip system to receive their tips in full, the right for gig workers to receive a more predictable contract, increased reform and protection for pregnancy, maternity related redundancies, the right for neonatal care leave and unpaid carers leave. So they are all sitting somewhere in the House of Commons in a draft document that we've yet to see, but we certainly know that they were the key headings, but we don't know anything really more than that at this stage about whether or not that'll be implemented in 2021, because obviously of the impact of the global pandemic. So moving on, I just want to, and the detail of these cases are in the narrative document to accompany the slides. So I just want to give you a sort of heads up about what the subject matter is in the case and whether or not you think there might be a subject matter that might be interesting to you. So number 10, the Alderhay case, is a public interest disclosure or a whistleblowing case involving a consultant. And I think the lesson to be learned here is about reputational risk from an organisation's perspective, and not to engage in a public slanging match whilst trying to save the organisation's reputation. You're trashing the reputation of the whistleblower. So an interesting case there. The Lafferty case is about a dismissal where the individual had been charged with a criminal offence but not yet incarcerated, and it was deemed to be an SOSR dismissal, so some other substantial reason dismissal rather than a misconduct dismissal. Wheely and University Hospitals case, really interesting one, especially maybe from the Equality Commission's perspective here. This was about the law with regard to contributory conduct, where effectively you're the author of your own misfortune, you know, you have contributed towards your ultimately your dismissal. And in this case, the individual suffered from bipolar disorder, which is a really interesting case and well worth a look. The Phoenix Academy Trust case is a case about what we call the vanishing dismissal. So where someone is dismissed in the first part of the dismissal procedure under the statute, and then is effectively reinstated on internal appeal. That creates what's referred to colloquially as the vanishing dismissal. So that's well worth a look as well. Gallagher and Abellio is a very unusual case where there were no policies or procedures followed whatsoever. The individual was dismissed on some other substantial reason grounds, and effectively the backdrop to this was a case where fundamentally the relationship between two senior members of staff had fundamentally broken down, and the dismissal was deemed to be fair. The last set of 5 cases, again, Forstater and CGD is a case about whether or not sex is an immutable philosophical belief. So in other words, you can't have people believing in trans men or trans women. Sex is biologically immutable. Really interesting case. Glasgow and City Council and Johnson is about whether or not foster carers actually have worker or employee status. Ferguson and Australia Management is a case about CHIPI, where there is a CHIPI reform that actually is beneficial to employees prior to the CHIPI transfer, and whether that variation stands up to scrutiny post-CHIPI transfer. Costano London General Transport should be viewed through the lens of COVID. This was about a bus driver who were given responsibilities that were of health and safety nature, and it's really interesting to see whether or not, in the light of COVID, whether or not people who have given extra health and safety related responsibilities would be protected under health and safety representative type roles. And lastly, case number 1, Morrison Supermarket and various claimants. This was a case that effectively has established the natural order of things for employers to be vicariously liable for the acts of their employees. Their employees have to act it in their course of their employment, and there must be a close enough connection between that and the work that they're paid to carry out. Okay, moving on. And just to finish with, in terms of 2021, as Paul had alluded to earlier on, it's anybody's guess where we are. There are cases that are pending in terms of MENCAP is a case about whether or not people are entitled to national minimum wage whilst asleep but on duty. The Coastal case is about what constitutes an inducement to a trade union regarding sacrificing collective bargaining rights. And the Brazil case I talked about was about the calculation of holiday pay using the 12-week back referencing system. There are also pending decisions on Uber, which will be happening shortly into the new year, and that will put to bed the final question regarding, are Uber workers either workers or independent contractors for the purposes of employment rights? And the Agnew PSNI case, again, will address the issue of holiday pay, which everybody's waiting for with bated breath. The unknown quantity in all of this is the landscape, what it'll look like after 2021. And Paul alluded to it there earlier on. Equality law is protected under Article 2 of the Northern Ireland Protocol. And so it's pretty safe in the sense that it will continue, and the Equality Commission and the Human Rights Commission have a really important role to play there. That's not necessarily the case for employment law. Employment law is one of the key sticking points between Boris and Ursula at the minute after last night's dinner, and the key issue there is whether or not there will be what's referred to as a level playing field. So there is what's called, depending on which newspaper you read, either an evolution clause or a ratchet clause regarding future developments in employment law, and whether or not the UK will be bound by those in order to create this level playing field between the UK and the other member states. It's no longer fish is the sticking point. The sticking point is the level playing field. And if we don't have agreement by Sunday, well, we are where we are. That's as much as I can say about that. Okay. Hopefully you found that obvious. I'm out of time. I'd like to field a few questions before I go.
Mark, thank you so much for your presentation. That was excellent, and so much detail in there. We have received quite a few questions, so I'm going to take 2 or 3 of those, Mark, if that's okay with you. So the first question is from an employer. They're asking regarding the Sizzlers case. Their question is, very often employees in these types of cases are keen to be made aware of the sanction that the person complained about received, and they're asking essentially whether this is a breach of GDPR. to give that information out?
Yeah, that's a good question. I mean, this question has arisen pre GDPR. To be honest, in many situations, the standard answer to this is that it's not within the gift of the grievant who's had their complaint upheld to know the sanction that has been imposed against someone. Now, the difficulty here is that it's very fact sensitive and it's in a very controversial area. So, say for example, during the grievance process, and the employee is asked, "Well, what do you want out of this? How will this grievance be resolved?" It's important to manage the expectations from the outset to say, "Well, look, we can't guarantee that the individual will be dismissed," for example, because if you mismanage the expectations and the individual has been disciplined, and then they walk into work the next Monday and the individual's still there, you're going to have an absolute, it'll be an absolute nightmare. So it's important to manage the expectations from the outset to sort of say to the individual, we can't guarantee what you want out of this grievance if it's upheld that you'll get, but we recognise that we owe you a duty of care and the appropriate actions will be taken. So whether that's, behavioural adjustment training or whatever it happens to be, I think rather than getting into the specifics about the sanction, I think you couch it in terms of the duty of care that we owe you and appropriate measures have been taken, but also managing the expectations about whether or not the individual is going to have to work alongside that. So, for example, a sanction might be an involuntary transfer of the individual who was guilty of perpetrating the offence, and they're aware that the individual is still employed but will no longer be working with you. And that's you're not giving them the detail of the sanction, but you're effectively saying this is how we're exercising our duty of care to you.
Great, thank you, Mark. Thank you for that. Second question I have here on a slightly different note. So this employer has asked, they have several employees who have cancelled their leave because they haven't been able to take a holiday overseas or indeed a holiday in the UK due to travel restrictions. So
yes,
what they're asking is, what would your view be with regards to employers stating that most employees should still be able to take their leave for rest and recuperation, despite coronavirus, and that only in exceptional circumstances can leave be carried forward?
Well, I'm not so sure about the exceptional circumstances, and that's the important thing to remember. The way that the law is couched, the legislation is couched, has yet to be tested. It talks about it hasn't been reasonably practicable as a result of the effects of coronavirus, and that's the impact on the worker, the employer, or the wider economy or society. So you need to be careful because we don't know how the courts and tribunals will interpret this. However, you're quite right to point out that the working time regulations are about rest. They're not about the location. So I don't think that it's a good enough excuse. But again, this is only an opinion. I don't think it's a good enough excuse to say my favorite beach in Benidorm is closed and I can't get access to it, so I can't invoke my right to take my rest from work. I think an employer would possibly challenge that to be able to say, look, this is about the rest. We're concerned about you burning out. We're not ordering you to have a staycation, but just because the location that you prefer isn't available, I'm not sure that would cut it.
Okay, brilliant. Thank you very much for that, Mark. Mark, I have one final question for you,
Sure,
and essentially it is, should an organisation record staff who are off as a result of self-isolation or because they have symptoms as part of their sickness absence?
I think they should, but obviously GDPR and confidentiality would be part of that. I mean, the question that I always have when people are recording things, my first question is, for what purpose? For what purpose are you keeping the record there? If you're keeping the record there to effectively use it as a punitive sanction about an individual who's off genuinely and is working within the legal framework, you have to ask the question, and why are you recording it? Is it with a view to challenging the person, saying, well, no, we don't believe that you should be self-isolating? So there's what has become readily apparent over the last 9 months is there is a lot of this is predicated on trust. A lot of this is predicated on taking people's word for what the reason they have, and you've lots of employers saying, "Have I right to see the a screenshot of the text that someone received from the public health agency or from the close contact trace service and stuff like that?" And the law on this isn't that prescriptive, to be honest with you. So a lot of employers are either taking the individual's word on it or are asking for those sort of evidential audit trails there. And I think the key issue is, like anything in employment law, if you go back to core principles about make sure you're procedurally correct and make sure you're being reasonable in all the circumstances. And if those twin approaches are largely followed, you'll not go far wrong. If you're looking for extreme forms of evidence, etc., the question might be, well, why is this employer looking for that degree of detail, whereas another employer will say, well, look, I understand that, because the practical reality, Roisin, is, to use a colloquial term, people are being pinged left, right, and centre.
Yeah.
You see it in schools, and you see it with teaching staff and stuff like that. So I mean, it's part of the culture now at the minute, just because that's where we're in mid-pandemic.
Yeah. Thank you so much, Mark. And definitely, it's such challenging times for employers. But I think the point you're making there is that the general principles and associated duties of care apply as normal.
Absolutely.
Listen, we have some more questions, but unfortunately, due to time, we're not going to be able to get through any more. But other than to say that that employment law advice and information that you've given us is invaluable to us as well as our audience today, Mark. So thank you again. And in regards to further questions, we will be providing sources of further support today, and please do follow up on that. So that brings our employer update today to a close, and we really hope that you found the session useful and informative. And we hope that there are plenty of practical tips that you can take away from today's event and apply in your own workplaces. And that you know where to find us, as well as our colleagues in the Labour Relations Agency, in the event that this has created more questions than answers for you, which we are conscious. As Paul said at the outset, today's event was really about providing the information and changing practices within workplaces. And as Paul and Mark have both alluded to, we are here to help you with that, no problem at all. So all that remains really is for me to thank you for your attendance and for being here with us today. We would ask you please to take a little bit of time to complete the evaluation form that you would have received along with your email invitation to today's event. We do value your feedback and we use that for future events. So thank you, and we would like to wish you good luck going forward, and to say that we look forward to working with you all again soon. Thank you very much.